Thank you, Judge. Before I continue with my argument, for purposes of the Victims' Rights Act, Mr. Morphew's daughters have expressed an objection or a support of the defendant's motion to reduce bond. Meanwhile, Suzanne Morphew's sister, who's also on the line here today, as well as her brother, who submitted a victim impact statement, both strongly object to any modification of the defendant's bond at this time. Judge, defense counsel is asking for a reduction of bond specifically for the reasons that the court considered. When the court had the indictment in front of them and reviewed the information that we presented with respect to our bond argument, the court considered, for example, his previous performance on bond, the previous amount and conditions of the bond, took into consideration all of those factors that defense counsel has now asked the court to consider here. But I think the most important thing that the court considered is the court had the actual indictment in front of her and read that this case is a very different case than the one that was filed in 2021. Obviously the facts of this case will be litigated in trial. Defense counsel is asking the court to consider that the evidence presented in the indictment is just slightly different than the 2021 case. Nothing could be further from the truth, Judge. In this case, the remains of Suzanne Morphew were found. The remains of Suzanne Morphew after an autopsy contained a chemical compound that Mr. Morphew had almost exclusive access to, tying him directly to the remains of his wife. The case in 2021 was arguably entirely circumstantial with no body. This case is very different. I'm hoping that the court has been able to at least review some of the transcripts of the case presentation in front of the grand jury. Obviously, the court has the indictment. The transcripts will also describe in more detail and more depth the weight of the evidence against Mr. Morphew as he sits here today. So I think I differ with defense counsel in his assessment of the case that's in front of the court. It is very different than the one in 2021. Judge, the court has also considered specifically the behavior of Mr. Morphew in 2021 with respect to his bond. I know that the defense did not have the benefit of being here during my bond argument, but specifically the court asked me, was there any bond violations in 2021? What were the terms and conditions of his bond in 2021? And the court had all of that information in front of her when you determined that this was a different case and so a different bond should be set. I differ with defense counsel in his argument where defense counsel submits that a bond is too high if someone can't post it. Obviously, our jails that are full with people that can't post bond would argue in a different direction on that one. But the reality is the bond that Mr. Morphew the bond that the court has set is consistent with other bonds that are currently set against homicide defendants in the 12th Judicial District. Judge, the court specifically asked defense counsel whether or not the defendant has been using any other name. And obviously we can talk about the reasons why the defendant might have been doing that. But it's not just his middle name that he's using. He's using a last name that doesn't have any relationship or connection to his given name at birth. He's using the name Lee Moore, which is not related to anything that the defense has presented. Specifically, he's using it to conduct business in Arizona, and that's the concern that people have specifically. In addition, Judge, the court asked whether or not he's been in another state for a substantial period of time. While I don't have any facts to dispute what defense counsel represented, I would note that the defendant has been traveling frequently with 2 vehicles, interchanging license plates on those vehicles. In addition, we also have information and communication to suggest that the defendant has actively attempted to move around large amounts of money to different accounts. He has put properties that he owns in family members' names. He has also traveled well. He is absolutely entitled to do so. He does have the means to travel out of the country. And it's those things that give us a lot of concern about not only the fact that this is a different case, but the fact that this is a different judicial district, this is a different district attorney's office, this is an entirely different landscape. And I can imagine that the court would agree with me when I say that the defendant is under very different peril than he was in 2021. And for that reason, we have been monitoring his communications as well as his movements in terms of financial information. And it looks as though he is doing a lot of activity in that regard. Judge, he does have substantial means, but we don't have any information that he's actually been working for the last 6 months. He's been living in Arizona, but our information, at least preliminarily, is that he has not actually had a job. He has he does landscaping work, but we have not been able to find any kind of incorporated business or any business name that he's operating under. So we have great concerns about what he actually has been doing in the last 6 months, where his money is going, and why he is now actively trying to shift around finances. All of those things give us great concern, Judge. I agree with defense counsel. The defendant sits here innocent until proven guilty, and I fully support that concept of our criminal justice system. But the court has to consider whether or not the defendant is a flight risk. And in these circumstances, in these very unique circumstances, a bond of $3 million cash only, consistent with other defendants in this jurisdiction, is appropriate, and the defense has not presented the court with any other material information that would support a modification of that bond at this time. And if I can just have one more, Judge.
Sure. I do have a question for you.
Sure.
Ms. Kelly. The license plate that you've brought up that was switched between vehicles, was that a license plate that was registered to Mr. Morphew or to someone else?
It is.
In his own name?
It is. It is an Indiana plate, and he's been living in Arizona for a long period of time.
Okay. But it's in the name of Barry Morphew?
That's correct.
Okay. Thank you.
As far as we can tell, I don't think we have any information that he's registered any vehicles in Arizona. He has not.
Okay. Thank you. Go ahead.
Thank you, Your Honor. So I want to be a little bit careful recognizing who our audience is, and it, of course, is the court. Your Honor, the transferring of large amounts of money, I believe, is a reference to a trailer that Mr. Morphew is residing in Arizona, and a home that Mr. and Mrs. Morphew had purchased in Indiana for roughly $200,000 and transferred it to his mother because his mother is residing there. Mr. Morphew's significant financial substantial means are something, of course, that has not evidenced itself so far in the roughly 9 terabytes of discovery that has been presided to the defense. And ultimately, the court should know that Mr. Morphew was in fact living in a trailer park in Arizona, and was driving, and his daughters were driving the same vehicles since those that had been seized and returned to them by law enforcement. There is not a substantial amount of money. I am hesitant and going to be very careful in talking about the one piece of factual evidence that the district attorney raises in addressing that. Insofar as the indictment, Your Honor, as the court knows, that is a cherry-picked piece of narrative that has been created exclusively by the district attorney, using agents by the district attorney, and by going through the grand jury, there is no opportunity for the defense to be able to publicly rebut anything that has been said. That is but mere allegations, and arguably and laughably, oftentimes wrong and incorrect. The BAM that the district attorney mentions that Mr. Morphew had access to, I want to be clear on, was prescribed to him in the state of Indiana in 2018. Mr. Morphew has not had access to BAM since 2018, and the indictment says that nobody in the immediate region, meaning the 12th Judicial District, who was not otherwise lawfully prescribed BAM, had access to BAM, leaving out the fact that Mr. Morphew himself has not had access or a prescription to BAM since 2018, and ultimately, law enforcement did not find any BAM in Mr. Morphew's residence, in his garage, or in his gun safe. And so this narrative that the people put in their indictment that Mr. Morphew has ties to and access to BAM and is completely silent to the fact that that was an out-of-state prescription legally prescribed to him for a deer farm that he had not owned in years, in my opinion, is something that is not particularly relevant to this court's analysis, only insofar as rebutting the fact that the people asked the court to take into consideration a one-sided indictment with a soundbite of BAM and leaves out the context in the initial and the additional narrative. And so the bottom line is, in this case, my premise and my argument remains, which is that Ms. Bryelson and I have the burden of representing an innocent person next to us, and we believe that the facts are going to be flushed out when given the opportunity for that to be a two-sided narrative and not a one-sided narrative that we then ask the court to simply believe and take as completely and totally truthful and accurate. Ultimately here, the purpose of bond is to ensure Mr. Morphew's compliance with court order. And we are, in fact, asking the court to only consider both what has been argued today as well as the statutory factors. Thank you.
So I want to be clear that the purpose of bail at this stage of a case is to ensure Mr. Morphew's presence at the time of trial and not to punish him before he has been convicted of anything. Pre-trial, my considerations in reducing bail or modifying bond are whether or not Mr. Morphew will come to court as directed, and whether or not he is likely to commit a new offense while on bond. There are several factors I may use in making this decision. There are several factors that weigh in Mr. Morphew's favor. Mr. Morphew has the support of his family, and he alleges several friends both inside and outside of Colorado. However, he did not identify those friends even in the sealed version of his motion, and his family lives largely outside of this state, and at least one family member lives between two states, neither of which are Colorado. That being said, I do note that, no disrespect to any of the other